Good afternoon, everyone. Welcome to the Appellate Division, First Department. We have several hours of argument time requested this afternoon, so please keep that in mind as I call the calendar and ask only for the time that you'll need to make your most important arguments. Remember that we have your briefs, we have a record, and we are fully familiar with the facts of these cases. First case, People versus Luis Leva. 4, 1, and 4, thank you. Ikram B. versus Abdelkader B. is submitted. Martins versus Memorial Sloan Kettering. There's no appellant. Submit. Okay, thank you. We'll take the submission. Consolidated Carpet versus Richter and Ratner. Submitted. Rizzo versus Weiss. Two minutes, did you say? 5 and 1 and 2. People versus Wiss Patterson. 5 and 5, 2 and 4. Thank you. Bond versus New York City Health and Hospitals. 5, 2 and 5. Thank you. People versus Elias Arroyo. Submitted. Vigilant Insurance versus MF Global. I'll grant the request. Access, you said? And you asked for 1 minute. Give you 5 and 3, 1, 5 and 2, and 4. If you need extra time, we'll allow you to do so. 5 and 3. 1, 5 and 2 and 4. Thank you. State Farm versus Solomon, submitted. Leighton versus Lowenberg is submitted. GS Capital Partners versus Ameritech is submitted. First case is People versus Luis Leva.
Good afternoon. My name is Lorraine Modello, and I represent Luis Leva. The SORA court erred when it improperly assessed 15 points in Category 11 for having a history of drug or alcohol abuse.
Counsel, even if we were to just subtract those 15 points, he would still be a level 2?
We also believe, as we have submitted and argued in our brief, that the court abused its discretion in denying the request for the downward departure.
What's your basis?
I'm sorry?
What's your basis for the downward departure?
The basis for the downward departure was several mitigating factors not taken into account.
Yes,
by
but
the
what are
RER.
they?
The first one was, these were all before the court below, that Mr. Leva was 50 years old at the time he was expected to be released, and there are social studies that indicate that at that age there is a reduced risk of reoffense. The SORA court seemed to misunderstand. Well, first the SORA court said, I don't believe in that. I know there are studies that say that, but I don't believe in that, which he really had to consider the mitigating factor. I'm not saying he had to accept it, but he had to consider it. And that statement shows that the court didn't consider it. The court seemed to conflate the physical, which the DA also does in their brief, the physical ability to commit a sexual act with the propensity or the likelihood of
Was there
committing a
any
sexual
expert testimony or other evidence submitted at the SORA hearing to support that?
There was no expert testimony, but the court accepted it. So it was an issue before the court. It was not that it was not raised before the court below. It was raised before the court below. The court just summarily discounted it. In addition, Mr. Leva had raised that he had an exemplary disciplinary record while he was incarcerated. His sentence was 10 years. He was set to be released after 7 years because he had earned all of his good time.
Is that the kind of thing of a kind or to a degree that's not adequately taken into consideration?
Yes,
under
it
these
is to a degree,
circumstances?
because the RAI has satisfactory and unsatisfactory conduct. And this is exemplary. It is analogous to the RAI has, did the person complete sex offender treatment or not take sex offender treatment? But as the guidelines state, the court can issue a downward departure if there is exemplary conduct in a sex offender treatment program. This is similar. There was exemplary conduct while he was incarcerated. He had only one Tier 2 infraction. It was 4 years before the SORA hearing. He had availed himself of every available prison program while he was there. He had earned every certificate.
Isn't that what one is supposed to do? How is that to a degree that's so much different?
It is not taken into account because all that's taken into account is whether your disciplinary record is satisfactory or unsatisfactory. It's similar to the same thing. It's here's satisfactory, here's exemplary. Exemplary is something that the court, in the SORA court, should have taken into account, and this court can take into account. That once he entered prison, Mr. Leva—
I understand that we can take it into account. I'm aware of that. I'm asking you why this is exceptional in this circumstance.
Why it's exceptional, because every single program that was available to him, he took advantage of, because he only had one single minor disciplinary infraction. Because what he did from the moment he entered prison is show that he was ready to re-enter society when he was allowed to re-enter society, which docs thought was at his conditional release date, obeying all of the rules and regulations of society, which make him at a very low risk of reoffending.
Thank you.
Your Honors, and may it please the Court, Anna Notchik for the people. The Court below—
I'm going to ask you why are these things exceptional? Counsel said that the fact that there's only one infraction is exceptional. The fact that he's 50 years old should be taken into consideration as a factor that is of a kind that should result in a reduced sentence.
Well, Your Honor, as to defendant's alleged exemplary conduct while incarcerated, that was fully taken into account by the RAI. In that, defendant was scored 0 points under Factor 13 for conduct while incarcerated. It is not comparable to a case like Williams, where this court found that there was exceptional conduct. In that case, there was letters of recommendation, and we just simply don't have that here. Further, as to defendant's age, all that was presented to the SORA court were generic studies, and there was no evidence that defendant in particular was less likely to reoffend based on his age. Further, the court properly assessed points under Factor 11 for history of drug and alcohol abuse. And if there are no further questions, we ask that you affirm.
Concerning the drug and alcohol abuse, what do you have? The statements of the victim?
Well, Your Honor, there are 4 reasons that the court properly assessed points under Factor 11. First, defendant admitted that he used alcohol and drugs while in the streets. He was referred to and completed substance abuse treatment. He was scored as an alcoholic on the Michigan alcohol screening test.
Did he initiate I'm sorry to interrupt you, counsel. Did he start the program, the substance abuse program, immediately upon entering his carceral state?
He was incarcerated at the time of the substance abuse
No,
treatment.
I know, but did it happen right away? Was that something he did upon being incarcerated?
I'm not sure of the exact time, if it was right when he entered. But also the victim did state that the defendant not only provided her alcohol, but was intoxicated during the encounters. And if there are no further questions, we ask that you affirm. Thank you.
Getting back to the alcohol question, the 15 points, there you had the statement of the victim where she surmised that he'd come home after drinking, and then you have him, when he began his sentence, to be in an alcohol program in prison. So isn't that enough for the court to surmise that the 15 points should be awarded for that category?
No, because the statements of the victim, it's a conclusion. She says he drank before he committed the crime. She was behind a closed door.
But she lived in the same house. She knew his habits. I mean, could one make the inference that she would know that he had this or something he did as a regular basis?
She would know is not clear and convincing evidence. I don't know if she would know. And Mr. Leva is entitled to clear and convincing evidence of that factor. There is no clear and convincing evidence. She says he was drunk, but she also says he opened her bedroom door. She was behind the closed door. The vague statement that he made that years earlier he had used alcohol and marijuana without the frequency, without how often, without when it was, without when the last time, that is certainly not enough for a history of alcohol or drug abuse.
Thank you. Thank you both. Rizzo versus Weiss. Mayquire.
May it please the court, my name is Todd Bacall and I represent Nick Rizzo. The lower court erred as though the motion was withdrawn from the calendar. The action was not discontinued.
Counsel, let me ask you, is it your contention that the settlement agreement here did not contemplate plaintiff ever intending to discontinue the action?
No, actually, the settlement agreement in paragraphs 3 and 6 specifically had that they were continuing the action. It said if the settlement was completed—
Yes, I said did not contemplate discontinuing the action.
Oh, yes, I'm sorry, Your Honor, I apologize. Yes, it did not contemplate discontinuing the action. It specifically, and of course the court understood that in its May 12, 2011 order. It was not dismissed as, cases cited, Gershel and, things like that. This is a case where the case was kept open by the court, by multiple clerks, and two justices of the court.
Was there any language that suggested it would be discontinued?
There was no language that suggested it would be discontinued. And as Mr. Weiss,
Well, wasn't it if there was full payment?
there was not full payment. There never.
But that was the
condition never
language.
occurred. Yes, if full payment was
Only
made.
if full payment.
Correct.
And there was not full payment.
Correct. And Mr. Weiss, his attorney, typed in and put a typewriter, language of discontinuing it with prejudice if that occurred. That was added by them. That
So
didn't
what
occur.
happened after the lack of payment here?
So what occurred was these two guys are friends. That's throughout the record and indicated. And they tried to see if they could resolve it over a number of years. And there's indication in the record of a partnership, separate and apart. And what occurred was eventually they went back and said, we'd like to get paid on this promissory note, which in fact was unquestioned. So the motion was refiled. We appeared in court on a preliminary conference. Mr. Weiss was there. Mr. Gelman was there.
When you did a summons in lieu of complaint, what happened when he asked for that to be withdrawn? Was the summons was withdrawn as well?
Well, Your Honor, that was unfortunately an artful language. You can't withdraw a summons in New York. You can only discontinue a case in court by CPLR 3217. There is no rule or law in the CPLR for withdrawing a summons. What occurred was these documents were e-filed together. They were as a summons with a notice of motion with the affidavit and the exhibits in one patch. So that is, the document itself, which was presented to the court, says notice of withdrawal of motion. And so the document that was in the system has all those listed.
Right, and that document that was filed, though, I mean, we can agree that it says that the plaintiff's summons and the notice of motion for summary judgment in lieu of complaint are hereby withdrawn, right?
Yeah, we're not disputing that it says that in that document, but it's a notice of withdrawal of motion from the calendar. It was set to occur on the calendar 4 days later, and so it was taken off the calendar.
But the parties continued to litigate, correct? They appeared for conferences, and presumably the calendar at those conferences had the index number of this case on them, correct?
Correct. And that all occurred prior to the statute of limitations. We relied on ECF, E-courts, the court clerk, Brendan Hansen, telling us that it's an active case. There's an email in the record where it says, is this case active before Justice Owing? And the answer is, yes, it's active, and we'd like to come in for a preliminary conference, which we did.
And in fact, defendants filed motions in this case, and they never really raised this issue until years later.
That's correct. This was not brought up until 2019, 8 years later, after there was a substitution of counsel. The case was fully litigated through motion sequence 2 and 3 for many years before this. And finally, what you have is a situation where the court was wrong. This court could have, if the court felt what we believe the case was not discontinued. But certainly, 2001 and the Court of Appeals in Ruffin versus Lyon has said this can be addressed. Gershel is no longer good law. Richards is no longer good law. The case is cited by the court below. The court below missed Mon versus CellSource, in which this court said you could have this situation of a withdrawn 3213 and then brought back again. Also, with respect to CPLR 205, which would be another chance if it was actually dismissed, which it wasn't, the court failed to make any kind of showing as to repeated negligent failure to prosecute. And this court said in U.S. Bank NA versus Fox on January 5th, 2023, that you have to make that kind of finding. The court is brought in. It's similar to the Sokoloff versus Shore case that is represented in our brief. But this court has said the same thing. Thank you.
Thank you.
Good afternoon, Your Honor. Stephen Pepperman for Respondent Gene Weiss. Your Honors, in 2011, this case ended. This case started—
Counsel, does the course of conduct between the two parties suggest that the case ended?
Absolutely not. In fact, the course of conduct, if you look at the documents that were submitted, merely shows that the plaintiff was being aided by my client to try to get coverage under an insurance policy that covered them for prior frauds. There was never discovery.
I thought you answered my question was, did the course of conduct between the two parties suggest that the case had ended? And
absolutely. Absolutely. In fact, between 2011 and 2014, absolutely nothing occurred. In 2014, Mr. Bacall was retained. He wrote a letter to Plaintiff's Defendant's Counsel and said, I've given you 30 days, I'm going to refile my motion.
There were preliminary conferences.
There was no preliminary conference, Your Honor.
Well, they were after defendant failed to pay, after the company failed to pay.
Yes.
There were conversations and settlement agreements following that period.
No, there were not. There were when the company failed to pay on this. There was a settlement agreement after the initial motion was made between Progressive and the plaintiff. My client had no part in that settlement agreement and, in fact, has stated he never signed that agreement, although it didn't obligate him to do anything. It was the plaintiff himself who withdrew the motion, as well as the summons with notice, in effect taking everything out.
No. That was at the point where the settlement agreement began.
Yes.
I'm talking about after the defendant failed to pay, not the
Nothing
fact
happened.
that—
Not a thing. And in fact, there is no preliminary conference. There was never a request for preliminary conference. There's no preliminary conference order.
Did the plaintiffs file a motion in 2017 to which defendants filed opposition?
Yes.
And then the court decided that motion, right?
Yes.
And then defendant filed a motion in February of 2019 to re-argue, and it wasn't until January 27th of 2020 that you're making this particular argument. So the defendants, you guys had participated in as if the litigation was continuing.
No, Your Honor. There is absolutely no evidence between 2011, the entry of the confession of judgment against the co-defendant on stipulation, and 2017, you will not see a document with an index number. There is no preliminary conference order. In
Then,
fact, what
okay, if that was in fact correct, and you're still, after 2017, you don't make this particular argument until 3 years later.
Your Honor,
You opposed the motions that were being filed, but you didn't make this particular argument.
Ronnie, I didn't come in the case until much later, and the initial motion took a year to determine. After that, and in fact, what we're arguing here is subject matter jurisdiction. I can theoretically wait until after the court issues a judgment and come in here and say the court has no subject matter jurisdiction because the plaintiff himself voluntarily withdrew this case on April 21st.
Also, is it your argument that pursuant to the settlement agreement that the matter will be discontinued before the settlement was paid in full?
No, in fact, the agreement says specifically after the agreement is paid in full, the defendant will issue a discontinue or withdraw the case with prejudice. What in fact happened in 2011 when it was withdrawn, theoretically it was without prejudice. And any time between that withdrawal and December 6th of 2016, plaintiff could have refiled the case and commenced an action. In fact, here what he's done is taken a case that was no longer alive. It no longer had no summons, no motion, no anything. There were no pleadings. How can you have a preliminary conference when you have no pleadings? Which is what the plaintiff wants you to believe, that there were conferences, that there were orders. There was absolutely nothing. In fact, Judge Maisley realized on motion number 4 that she probably didn't have any authority to do anything because there was nothing before her. When the 2017 motion was filed a year and a half after the statute of limitations had expired, there was no summons. In fact, plaintiff's counsel says—
No, I understand that because he withdrew the summons in lieu of complaint, I'm asking you something else. Are you saying that after the failure to pay, there were no conversations between the plaintiff and defendant with regard to negotiations?
Oh, there were—
Attempted settlement agreement.
There was conversations between attorneys trying to get a third-party insurance company to possibly give the plaintiff some recovery.
And were there any conversations between the plaintiff and the defendant?
I can't say that. I know there was letters that say my client talked to your client. They're trying to work something out, get him coverage. That's it.
Wasn't there a payment made under the stipulation, at least one payment?
By the corporation, not by my client. He had no obligations to make any payments whatsoever.
That's true, and that was the case of the settlement agreement. But if the settlement agreement wasn't satisfied, then what was written was that he had not waived any rights against the individual defendant.
He could have started another lawsuit. In fact, Mr. Gelman told him in 2014, if you need to start a lawsuit, start a lawsuit. We'll cooperate. This is 2014. Nothing happened until the clerk on a regular saying, hey, we have this case on our calendar. What happened here? And Mr. Bacall said, oh, it's active. And then, in fact, a year before, he said, we're going to file for preliminary conference, which he couldn't have done because the issue was never joined.
Thank you.
My client never appeared.
Thank you.
Thank you.
Your Honors, in fact, there were communications as occurred between the parties, and there was a preliminary conference. It's listed at R199 of the record. I mean, there was no order because Mr. Weiss said, let's see if we can resolve this further, and the court allowed the parties to continue to do so. But there was a conference. Mr. Weiss was there. Mr. Gelman was there. I was there, and my adversary was not, because he joined the case 3 years later. This all occurred prior to the expiration of the statute of limitations, and what occurred here is there was correspondence back and forth. The letter that appears at, I think, 230 and 231 or 232 of the record is what he's indicating. Mr. Gelman said, if you want to discontinue the action is valid, but if you want to discontinue it, we'll waive the statute of limitations. Otherwise, every single time in all the correspondence, including when he told the court, the case is active, my client is a defendant, and a stipulation of discontinuance would need to be filed. Thank you.
Thank you. Thank you both. People versus Wiss, Patterson.
Good afternoon, Your Honors. May it please the Court, my name is Sarah Chaudhry, and I'm counsel for Appellant Wis Patterson. Mr. Patterson is before this Court seeking a reduction in his post-release supervision term from the maximum of 5 years to the minimum of 2.5 years. Just by way of background, well, first of all, Mr. Patterson pled to first-degree, after a guilty plea, pled to first-degree robbery and first-degree burglary charge and second-degree robbery. By way of background, this incident arose when Mr. Patterson and his co-defendant, Mr. Williams, went to the complainant's apartment, who was known to Mr. Patterson, and demanded...
Counsel, in your brief, you make a good point about the disproportionality concerning the co-defendant. However, the co-defendant did not have a criminal record, did he? Whereas your client did.
Okay, so the co-defendant didn't have a criminal record, but I'd like to talk to the Court about Mr. Patterson's alleged, or rather, he did have a minimal prior criminal record. So first of all, his only other felony offense occurred when he was 16 or 17 years old. It's unclear to me why he wasn't adjudicated a youthful offender for that offense. However, I think it bears consideration that the United States Supreme Court itself has stated that children should be treated differently in terms of culpability. So for the prosecution to point to an offense that occurred when Mr. Patterson was a mere teenager, and that Mr. Patterson from the age of 16 until this offense stayed out of trouble, didn't have any interactions with the criminal justice system, is an inadequate basis upon which to state that.
The 5 years of post-release supervision, that was bargained for, right? Under the repleader, under any circumstances, that it was always 5 years of post-release supervision, isn't that right?
It was always 5 years post-release supervision. However, just because it's a bargain for sentence, the Court of Appeals' recent decisions, actually just this week, the concurring justices have stated that a bargain for sentence is a consideration, but it's not where the inquiry stops. I would submit to Your Honors that this is a case that cries out for reduction given the stark disparity in the sentences imposed. For instance, this court in People v. Barone, even though certain of the defendants whose sentences were ultimately reduced did go to trial, this court determined that their sentences of 5.5 to 16 years and 7 years to 21 years were starkly disproportionate to those defendants who pled to lesser offenses, one of whom had cooperated, and received probationary terms.
Counsel, did the co-defendant, I'm sorry to interrupt you, did the co-defendant also abscond?
The co-defendant received just 1 year of city jail time.
No, but my question is, did they abscond? Your client did abscond, right?
Well, Your Honor, my client did abscond, that's true. However, as noted by...
Did the co-defendant abscond?
Co-defendant didn't abscond.
Okay.
But even in People v. Andrews, where this court reduced a sentence, and the defendant there not only just absconded between any sort of plea and sentencing, the defendant there just picked up and left, and there was a trial held in absence of the defendant. This court took a look at that and said, even though that occurred, the stark disparity between the sentences imposed on the co-defendant and this defendant warranted a reduction. So there, even though the minimum charge for that defendant in People v. Andrews was 15 years, this court determined that the sentence should be reduced to 5 years to life. So is it regrettable that Mr. Patterson absconded? Yes, but is it also true that even the very first plea that he was offered was 9 times the amount of what the co-defendant received, even though the co-defendant's conduct, according to the complainant, was far more egregious. The co-defendant was the one who stole the complainant's wallet. The co-defendant was the one who pushed his phone out of his hand when he attempted to call the police. The co-defendant was the aggressor here. Mr. Patterson, while not diminishing his culpability here, he did not take those actions. He didn't threaten the complainant with a taser, yet he's serving a sentence.
He handed the taser to the co-defendant?
He did, and again, not diminishing his conduct, even if this court were to, as obviously...
And when he came back after absconding, absconding pending sentence, mind you, he came back with a new case, not that he just returned on his own. He had a new case, right?
Well, Your Honor, he did return on his own, but he was charged, he went to the precinct himself. He admitted culpability for an offense that he did not commit, and so was charged there. But it wasn't like he was picked up off the street after committing.
So then that's a yes, he had a new case when he came back?
He had a new case but he went to the precinct voluntarily. But yes, he did. Again, though, all of this subsequent post-plea conduct...
But isn't that when you are released pending sentence or when you are out pending sentence, there are certain conditions, and one of those conditions is returning to court, which we clearly know he didn't do, and one of the other conditions is that he stay out of trouble, so to speak, right? Not pick up any new cases. both of those things happened here.
And he suffered a penalty for it. He received, the initial offer was, had he abided by those conditions, he would have received 4 and 5. He received 5 and 5. But that 5-year term was always what he was presented with. And regardless of all of his subsequent conduct, which I am not in any way diminishing, he was always receiving a sentence that was 9 times the amount that his co-defendant did.
Thank you.
One of the principle of proportionality is intrinsic to the fair administration of our criminal justice system. This is
Thank
literally
you,
what.
counsel.
Oh, sorry. Thank you.
You have rebuttal time.
Good afternoon, Your Honors, and may it please the Court, Emily Galt on behalf of the people. I just want to start out by pointing out that under the Less is More Act, defendant can receive the exact reduction he's asking for. For every 30 days that he's in compliance with his supervision, he will get a 30-day reduction. So exactly what he's asking for, 2.5 years.
While that may be true, I mean, I do think that defendant has a point. The co-defendant here was, according to the complaining witness, right? Not according to the defendant, but according to the complaining witness, it was the co-defendant who basically did everything in this transaction, had the taser, threatened him with the taser, took the wallet, slapped the cell phone out of his hand, yet he gets 1 year. I understand you have that prior conviction, but as defense counsel points out, it's 14 years old when he's 16. How is that equal? How is that proportionate?
So I think we're overlooking the fact that this crime occurred because of defendant. Defendant was the one who had a
So
prior.
even if defendant is the mastermind, even if it was his idea, so he handed over the taser, but co-defendant did all the action.
Defendant was still the one who recruited his co-defendant to help him commit this forcible burglary and robbery. And all this discussion about the co-defendant, this was in front of the sentencing court, and all parties discussed this in detail about the different sentences that the people were offering to defendant versus the co-defendant.
But I still don't understand, what do you base your difference on?
What do we?
The difference in sentence. Why is it that the co-defendant deserved 1 year while this defendant deserved more than 5, you recommended, right?
Well, the people below put on the record that the co-defendant had no prior convictions, which we addressed, defendant had one, and yes, it was from a while ago, but also defendant had open cases during this case. He had a case, a misdemeanor
Certainly you're
case.
not punishing him for open cases where he's not convicted and presumed innocent,
No,
right?
but that along with his behavior throughout the case, there was evidence in the record that he had lied to the court on multiple occasions, that at arraignment, he claimed that he had no idea who the victim was. Meanwhile, he was selling drugs to the victim and was extorting the victim in the past. He was dishonest about his home ownership. And then on top of that,
So even if that's true, that warrants a 4-year difference?
the people also went through the differences, or discussed the co-defendant. They had met with the co-defendant's family, and I guess the co-defendant was on the verge of homelessness, so they said that any prison time would put his whole family on the street. There was nothing about defendant in that regard. There was no evidence that the co-defendant ever misbehaved in court, ever lied to the court. There was also no evidence that the co-defendant even knew the victim or had any prior relationship with the victim until defendant recruited him to commit this crime. And also, as Your Honors pointed out, defendant absconded for 7 months. He took a plea deal. He agreed to the 5-year terms of post-release supervision under the original agreement. And then after he absconded for 7 months, he went to the police department, confessed to committing a crime that he never committed and later admitted that he didn't commit. And his reasoning was—
Well, he did pay a penalty for absconding, right? I mean, there was an extra year in jail. He was not afforded the benefit of the repleader, correct?
He was not afforded the benefit of the repleader. He was if he complied with the terms of the agreement, his first-degree burglary would be he could replete
Would have been reduced to an attempt, and it would have been 4 years instead of 5.
Yes, and then he kept the same term of 5 years of post-release supervision and got 1 additional year in jail. So given all of this, defendant is not deserving of a sentence reduction. We ask that you affirm. Thank you.
Okay, so as an initial matter, the prosecution repeatedly states that my client recruited and was the mastermind here. Some of those those assumptions are not a part of the record. I think what we have here in the record is that the co-defendant was the far more culpable party in terms of his conduct during the interaction. Now, with reference to any sort of other criminal or open cases—
You do have in the record that the taser was provided by the defendant.
Right, I'm not saying at all, Your Honor, I don't mean to be diminishing my client's culpability here. But I think that regardless of the Less is More Act, this court, it's incumbent on this court, as well as all the courts of this state, to ensure that the principles that underlie our justice system are honored. The principle of proportionality here has not been honored. In fact, I would submit to your honors.
Of course, that's if you look at it only as the defendant in this one very narrow moment only handed the taser, as opposed to the fact that, well, they were friends, he recruited him, he provides him with the taser, the person who gets the taser is the one who commits all of the acts. I mean, oftentimes that's why one takes a plea.
Well, Your Honor, even if we were to assume that their culpability, and correct me if I'm wrong in terms of characterizing what you're saying, but even if we were to assume that their culpability was the same here, the principle of proportionality requires there to be a reduction when it's not honored in situations like this. The prosecution itself can't really point to any determinative factors that would require a sentence that's 9 or 10 times the amount. So the open case that was referred to, the misdemeanor, driving with an aggravated unlicensed driving, upon information and belief, that was due to the inability to pay fines. The Driver's License Suspension Reform Act, which was recently enacted, was actually enacted to address such injustices where poor defendants, such as my client, are subjected to criminal charges. Now, if I could just respond to also the prosecution's assertion that the co-defendant was, his family was going to be out in the street. We're dealing with people here, both of the defendants here, or sorry, yeah, both of them. These are people who are not of means. These are poor people. My client had a son whose life he was incredibly active in, had a job, was working for Amazon as a truck driver, and was sentenced to 5 years in prison, and now a 5-year post-release supervision term, and his co-defendant walked away with 1 year of city jail time.
What about the Less is More Act that counsel commented on?
So the Less is More Act, for sure, if he's going to abide by what he's supposed to do, that will reduce his post-release supervision term. It will say, it's reduced to the 2.5 years. That's still half a year to a year more than what has been determined to be the most prime amount of supervision. And again, I would submit that the Less is More Act doesn't, it's not a way for the prosecution to argue that this court should not take a look at this case and exercise its sentencing discretion when one of the primary facets of our criminal justice system here has not been honored. And just the last thing I'd like to say is that in Justice Troutman's concurring opinion in People v. Baugh this week, she discussed how the intermediate appellate courts are the prime avenues where certain biases that might have informed a plea should be addressed. Some of what we have in the record here, it seems as though there was some personal animosity between the prosecutor and the client. Again, that's, I don't think that should be the basis upon which you're making a determination, but these biases are the ways, should be corrected by, when you're looking at just...
I think we understand your point. Thank you very much. Thank you both. Bond versus New York City Health and Hospitals.
I'm disqualified on that one.
Justice Rodriguez is recused.
Good afternoon, Your Honors. My name is Brian Heller of Schwartz, Perry & Heller. May it please the Court. The main question before the Court in this employment discrimination action is whether the New York City human rights law protects an employee who complains about discrimination and then has all of their work taken from them and given absolutely nothing to do for almost 8 months. The lower court was wrong to hold that the city law, the broadest law in the country, does not protect that employee, particularly since that same conduct is protected under federal law. Here, it is undisputed that on March 6, 2013, plaintiff Lori Bond complained about sexual harassment from her supervisor, Matthew Binder, writing that...
Counsel, with respect to the constructive discharge claim, she worked for Dr. Capone from April to October 2013, correct?
Well, correct. She met with him.
And from the get-go, he was not giving her very much to do, right?
He gave her nothing to do. He didn't meet with her.
But does there have to be, for a constructive discharge to occur, doesn't there have to be some rather faster decision that you're leaving? Like, I'm out of here because he's not giving me enough work?
Well, this is a unique situation. This was a temporary transfer. This was because of her complaint of discrimination to remove her from the people she was complaining about. And what happened, she was going to be given a temporary transfer to Dr. Capone. But the reality was that she was given absolutely nothing to do.
It became like a purgatory.
It became, and
He was stuck there, is what you're saying.
Well,
yes, Your Honor.
while my colleague was describing it as a purgatory, basically she was bored to tears.
Yes, Your Honor.
That's fair. And basically, between April and October, for whatever reason, there was a greater degree of absenteeism, et cetera, during that period.
Yes, she was given nothing to do.
Sir, I understand that, but
Yes.
from a certain point of view, and not making light of the hostile work environment or the retaliation, which are other causes of action, but constructive discharge, you wouldn't, as much as she was bored to tears, you wouldn't describe it as so intolerable, because usually constructive discharge is really an aftergrowth of the hostile work environment. There's no allegation, nothing in this record that Dr. Capone verbally abused her or mistreated her. You would agree with that?
I would, but I do think that that question really narrows what a constructive discharge is. And it was the removal of the responsibilities. Now, in the United States Supreme Court, in the Souter's case, identified what could be a hostile work environment, what could be a constructive discharge, and talked about removal of responsibilities.
So is it the humiliation that's involved with that, or is it something else? I mean, does it have to be something deliberate that was done in terms of, you know, berating her or something of that sort? Or can it just be that she's humiliated and, you know, her worth devalued by the fact that she was in a very responsible position and now is just put to sit at a desk?
Yes, looking at the reality of the situation, having nothing to do for about 8 months becomes deliberate action. That is an action that's taken.
And counsel, this particular topic that we're focusing on, this is an issue that a jury should get to evaluate, right?
Absolutely, Your Honor, without a doubt. This is and this really narrows the law. That's the real danger of the precedent that was established by Justice Love, that by saying that it's acceptable for an employee who complains about discrimination to be put in a dead-end job with no responsibilities, no job function, and no reason to think that's going to change.
But isn't it ironic and that we know that when you have teachers that are alleged to have committed misconduct and they're sent to the rubber room, they seem to be pretty happy with that.
I don't know if I would agree with that, Your Honor. We've represented some teachers sent to the rubber room. But to take that away, to say that just because she's getting a salary, that it's not damage, is really a danger, because the Second Circuit has recognized under federal law that a removal of someone's duties, and in this case, as in the Second Circuit said in Kessler, it was such a removal of responsibilities that it was a setback in her career, is really dangerous.
But isn't case law in the state, I think the Gaffney case, that the standard for constructive discharge is even higher than hostile work environment? Would you agree?
I would. It's a separate action.
That's my point. The point is we're not making light of everything else here.
Understood.
In this context, but focusing on constructive discharge for 8 months, and usually, my reading of the case law, both state and federal, there's a sense of immediacy to the kind of environment that would trigger. That's why it's constructively discharged. In fact, the Souter case describes it as a de facto termination.
Yes.
So in that context, they talk about an intolerable work environment with very strong language there. Again, I'm not making light of the boredom and what happened here. The question is it enough on summary judgment? Is it enough to say I was bored for 8 months, or do you need more without making light of all the other stuff that happened to her from March up through April?
Well, I don't know if you can divorce the two, but in conclusion, this case where she has nothing to do, a person with a doctorate degree in pharmacy who had been doing very complex work and who was actually being requested at the same time she has nothing to do, to have to just sit on a shelf and just accept that, does that at a certain point become intolerable? She was writing to EEO, complaining about how intolerable it was. She was having absences. There's enough here for a jury to find.
Thank you.
Thank you, Your Honor.
Good afternoon. May it please the court, Lorenzo De Silvio on behalf of respondent H&H.
So counsel, oh, sorry.
Okay.
This issue of the erosion of her authority or her duties at work, why isn't that something that a jury can decide what's reasonable if it was deliberate, as the cases would suggest?
I believe there could be a fact question as to whether a reasonable person would find this so intolerable, but for deliberation, there's no fact issue because it requires either an intent, like your days are numbered here, like some of the cases, or circumstances not present here that go beyond ineffectiveness.
Well, why don't we start with where counsel left off, that you have a person with a PhD who was given very interesting, complex work, was constantly congratulated and everything else. Then she has a sexual encounter with someone superior to her, and things begin to devolve. And she is at the point 6 months before she finally says it's enough, is put in, to sit at a desk and have nothing. So someone with a career, who's interested in a career, who's interested in advancing, and who's put at this desk, this dead-end position, is that not enough to meet the standard here? I mean,
No.
Maybe other cases had other fact patterns, but what about this one?
No, because it's a two-part showing. And on deliberate creation, there's crucial context that matters. The reassignment here was requested by plaintiff.
Not this
She
one.
wanted a reassignment. She got a reassignment within 5 days.
So any reassignment is fine.
She got a reassignment. The EEO process took over, and there's just no evidence here on the basis of which we can let's call this investigation substandard. There's no basis that this substandard investigation was because Bond is a woman or because she had complained of hostile work environment. And Capone had no connection to anything that happened before the transfer. There's no evidence that he knew about the reason for the reassignment. And even though she didn't meet with him for 4 months, and then eventually got work that she considered busy work at the end of those 4 months, it's just not enough to get to deliberate conduct. That's negligence, that's ineffectiveness, but we did something here, we did something substandard, but that's not enough for constructive discharge. I'd like to turn to the retaliation claim next, if the panel will permit. So on the retaliation claim, it's just not the case that a reasonable person here would base their decision about whether to complain about discrimination again on not getting the preferred assignment and on certain things that are just too speculative here. I certainly recognize that Bond had a doctorate, that she was doing things that she was not doing after the assignment. But the fact is, she did ask for a reassignment, so the fact of the reassignment can't form the basis of it. I certainly get that she didn't get the preferred assignment that she wanted, but we again have to look at this in context. She asked for a reassignment on the 5th. By the 10th, she was in Capone's group. She talked about Epic on the 5th. That was after she had asked for a reassignment. There's no evidence that Epic was available to her. She asked about a different workstation on the 8th, 2 days before she went to Capone's group. She asked about working opposite hours on the 9th, one day before she went.
You're saying that she was reassigned and she was reassigned, but what was she doing once she got to these reassignments? Her duties were continuously diminished, right? So until to the point that we're now pushing to that other issue we were talking about earlier on. But it's not as if she was reassigned and everything was great.
Your Honor, I will be direct. I think the retaliation claim can go forward with respect to no work for 4 months and the 7-month investigation. It should not go forward with respect to what Capone did, because he's just a non-player in any of this. A boss might not meet with someone just because they have a new person on their team and other things are going on. And there's other things like Ramla Khan didn't join a call on the very day that Bond disclosed their sexual harassment claim on that afternoon. The timesheets issues was resolved quickly. She never had to do her timesheets in front of Binder's office, never reported to Binder after the EO process took over. And there was a Bellevue meeting where they said, we need to do this according to our schedule. Bond interpreted this as it must be coming from Ramla Khan and Binder, but that's just not the kind of thing that a reasonable person factors into the calculus of whether they would or wouldn't be dissuaded. So this court should be careful about what parts of the retaliation claim can go forward, but the discrimination claim just has nothing to do with her status as a woman or her complaint about hostile work environment, and the constructive discharge claim just doesn't clear the high hurdle of more than negligence to get to deliberate creation of a workplace so intolerable. That's the city's argument.
Thank you.
Thank you.
Just briefly, I don't understand this argument about how it has to be deliberate. She's sitting there for 8 months with nothing to do. At a certain point, that's got to be deliberate. She's earning a salary. This probably would have never survived in a private workplace. This is not about what Dr. Capone did. He just didn't need her. The city has not put forward any business reason for why she was transferred to Capone. She was put in that position to shut her up and to wait until she would go away. And at a certain point, when it gets to 8 months, a reasonable jury could find that that's exactly what she did, that her departure was.
So you're not contesting that deliberateness is an element. You're just saying that deliberateness can be inferred by the extent that she was with Capone, that correct?
Whether it's an element or not, I don't know, but it definitely exists in this.
Our case law seems to say it is.
I do think that putting her in that position and leaving her there is deliberate, and it's deliberate across a wide array of people here. Ram Locken, of the keeping business away from her, EEO ignoring her.
Is there anything in the record with regard to Dr. Capone?
Well,
whether or not he knew or didn't know?
Who knows what he knew? There's nothing in the record that's either way. There's nothing in the record for no testimony. The only reference is a handful of notes from the EEO report that Tanya Pierre wrote after Lori Bond left. And another issue here is there's really just not enough evidence of what happened from the defendant's point of view. We haven't really talked about it, but they have not met their burden of showing evidence.
So why did she wait 8 months? I mean, someone with her background caliber, which as I read is outstanding, I wouldn't tolerate that for a week. So you're saying 8 months, and I believe the case law had the temporal component separate from the deliberateness here.
Right, well, that's the problem with constructive discharge, because if she leaves too soon, then she didn't give them enough time. She wasn't patient enough. She was told in writing, this is a temporary transfer. You'll go right back to everything as soon as I'm done with the investigation. And what really seems to happen is that OEO just dropped the ball. Tanya Pierre was too busy. Her report talks about how they were understaffed, talks about Hurricane Sandy, and Lori Bond was just left there to rot. So did she wait too long? Maybe, but either way, a jury could find that she was forced out of this job.
Thank you.
Thank you.
Thank you both. Vigilant Insurance versus MF Global.
Good afternoon. Just a year ago, this court ordered these insurers to pay full coverage to MF Global on its $141 million loss. And down below on remand, the court credited these breaching insurers with almost $20 million with above-limit payments that
We didn't reach damages, though, in our previous decision.
I'm sorry, excuse me?
We didn't reach the question of damages in our previous decision.
You did not reach the question of damages, but the loss is unquestionable that it was $141 million. And these insurers were responsible to pay their allocable share of that loss. Instead, they were credited with above-limit payments that were not payment of loss, that was not collectible as loss under the bond, and it was not received in connection with the indemnifiable loss, the indemnifiable act that gave rise to the loss. If Section 6.7 under this bond, it's a loss valuation provision, and it determines the amount that's collectible under the bond for loss by permitting deductions only for loss for property received in connection with the indemnifiable loss.
Received from any source whatsoever, it says, correct?
It does say that, but it needs to be paid in connection with, and the insurers even concede that the in connection with requires a causal connection. The underlying bad act, the Dooley's trading, must cause the receipt of that payment. Dooley's, there is no connection between the Dooley's trading and the receipt of a payment by settling insurers who were paying prejudgment interest, not on Dooley's trading, but on their own breach of contract. Dooley's trading did not cause these settling insurers to breach their contract, to refuse to pay.
Well, Dooley's trading caused the, sorry to interrupt you, counsel, but Dooley's trading caused the loss, the initial loss. It's the whole casus belli of why we're here.
it caused the initial loss, but now we have to quantify the amount of that loss that is collectible. The amounts that were paid above limits, the $20 million paid above limits by these insurers, were not paid for that loss. They were paid as a result of their own independent superseding breach of contract, where they refused to pay. They breached their contract, and they exposed themselves to extra contractual liability under CPLR 5001. Dooley's trading did not cause these insurers to breach the contract. It did not cause them to be responsible for amounts that exceeded the limits. Those limits cannot be applied under 6.7. They have to be, we're determining the amount collectible. If it's not payment of loss, it's not deducted from the amount that's collectible under 6.7.
Counsel, going back to from any source in connection with, there was no continuation of that thought, any limiting language that would maybe support your argument. It was just very broad, and that's that.
6.7 is not broad at all. In fact, if you compare 6.7 to 6.9, 6.9 actually talks about a payment that is received under the bond. So it refers specifically to payments by insurers under the bond, and it only speaks in terms of payment in respect of a loss. This 6.7 speaks in terms of a payment in connection with the event that caused the loss.
But it says in connection with any matter from which an indemnifiable loss has risen. Why doesn't this count?
And that is Dooley's trading. That's the malicious act that gave rise to the loss itself. There's a supervening event and a total disconnect. There's no causal chain between Dooley's trading and the settling insurers breaching their obligation to pay under this bond.
It seems that that would qualify as any matter.
No, any matter, it's undisputed in this case that the any matter is Dooley's trading. That's the covered act that gave rise to the loss. The property that gets deducted is property that is received in connection with that. It reduces the actual direct financial loss that was suffered as a result of that conduct, not an independent act of these insurers that breached. When New Hampshire wanted to define and what to do with the payment by insurers under the bond, it did so. It knew how to do that. It used that exact language in 6.9. It did not do it in 6.7. 6.7 does not apply at all to reduce and give these breaching insurers credit by amounts paid by other insurers. With respect to Axis, Axis has no whatsoever. They have specifically waived their right to use the attachment provision in the Liberty policy to defer the accrual of prejudgment interest here. What, in your decision a year ago, Axis was held liable for breach of contract. All of its claims were dismissed. Coverage was absolutely resolved. All of the elements of coverage were established. They had an identical ruling with respect to New Hampshire. And to go back after that ruling and to having never used the attachment provision as a defense to liability and having determined that they were liable, they can't go back and then try to seek and employ an attachment or exhausted related defense to the accrual of prejudgment interest thereafter. Their time to raise attachment as a defense, exhaustion as a defense, was at the time that MF Global moved for summary judgment. If there was a defense to that liability—
They didn't brief the issue in 2017?
They never, ever used it as a defense to liability. The only thing they did was to say in response to a request for prejudgment interest was to say they referenced the attachment provision. The court never reached that. Axis never appealed that. This court never reached that decision. This court dispositively ruled that there was a breach. Their time to use exhaustion as a defense to liability was before this court ruled. They never did that. They can't thereafter try to undo that ruling by going back and seeking to use an exhaustion-based defense when they didn't use it as a defense to liability when they had the opportunity to do so. They're precluded from raising the exhaustion-based defense in response to when we're talking about when prejudgment interest is accrued. It accrued with respect to Axis in July of 2008, exactly when it accrued with respect to New Hampshire, the primary.
You have rebuttal.
Thank you.
Good afternoon, Your Honor. Caitlin Halligan for New Hampshire. I would like to address the issue with regard to the meaning of Section 6.7. Counsel for the other insurers will address the issue specific to those policies. So, as the exchange with the court, I think, reveals, the real question here is whether or not the above limit payments constitute any property received from any source, which, by the way, specifically includes interest, which is what MF Global said the above limits payments were intended to encompass. And finally, whether or not those payments are in connection with any matter from which the indemnifiable loss has arisen, because that's exactly what 6.7 requires. It's at page 253 of the record. I want to focus on the last requirement and address the points that MF Global's lawyer just raised. It's certainly true that all of these payments that were made by the settling insurers were in connection with Mr. Dooley's trades. MF Global does not contest, and you can see this at pages 12 and 25 of their brief, that the trading is, of course, the matter from which the indemnifiable loss arose. We also know, because the Court of Appeals has told us, that the phrase "in connection with" is really expansive. It only requires some causal relationship. So as a matter of basic common sense, it is very clear that the entire amount of the payments made by the settling insurers, both limits and above limits, had some causal relationship to Mr. Dooley's trades. They were the only reason those payments were made, in fact. And if common sense didn't answer the question, the settlement agreements themselves certainly do. The settlement agreements say explicitly, and I'll give the court the cites, that the full amount of each settlement payment, full amount, to be clear, includes both limits and above limits, that the full amount was made to release any claim in connection with defendant's trades. And that's at pages A826, 844, 858, and 871. And likewise, what is being released, which is the MF Global claim and loss, is defined very broadly to include anything in connection with those trades. So that answers the question. Now, MF Global clearly does not like the terms that it agreed to, both when it signed on to 6.7 and then again when it entered into those settlement agreements, knowing full well what 6.7 says. This appears to us to be a one-of-a-kind bond. We have looked. We have not found anything similar out there anywhere, nor has MF Global pointed to anything. So the notion that this will somehow be disruptive or chill settlement, I think, has absolutely no foundation. I think to the contrary, what MF Global is asking you to do is to write limits into Section 6.7 that don't exist. And this court doesn't sit to do this and has to respect the deal that the parties struck. And so we ask the court to do so and to affirm Supreme Court. What MF Global is asking you to do instead, as Supreme Court said, is to circumvent the clear policy language. With regard to the other provision that Ms. Doherty cites, 6.9, that has to do with subrogation, which is not at issue here. There is no subrogation. I would also point the court to 2.50. 2.50 defines an ultimate net loss, and it does carve out very specific items that don't count, for example, certain employee expenses. That confirms that when these parties wanted to carve something out, they knew well how to do so. They did not do so with respect to Section 6.7. I'd like to turn briefly, if I can, to the question of the prejudgment interest accrued during the bankruptcy stay. Supreme Court made a legal error here. It believed that it lacked any discretion to decline to award prejudgment interest during the time of the bankruptcy stay when MF Global refused to consent to allow the litigation to proceed. If you look at page 22 of the opinion, you will see that the court says, quote, CPLR simply does not have a provision for delay.
Is there any basis in law to toll the provision, to toll that payment?
Your Honor, we understand, of course, that the prejudgment interest provision is very broad, but neither this court nor the Court of Appeals has ever said that the only exceptions are ones that are written into the statute. So, for example, with respect to punitive damages, with respect to, if I may finish my answer, with respect to a windfall to the plaintiff, courts have allowed exceptions there, even though they're not codified. So all we would ask you to do is to send it back to the trial court. I know this case has been around for a long time, but on this, and I know before many members of this panel, but on this discrete point, and to clarify that the court does have discretion if it chooses to do so, where here, in this very specific circumstance, the only examples we've found anywhere in the country actually come out the same way, where a stay is entered by another court, the litigant has no power to move forward, the opponent refuses to allow that to happen, and so the interests implicated in prejudgment interests are not at play. Thank you, Your Honor.
Thank you.
Good afternoon, Your Honors. Kevin Matesic for Respondent Liberty Insurance Underwriters, Inc. I'd like to address the application of the interest issue under 5001 of the CPLR and why it was appropriately applied by the Supreme Court below in this instance to only apply from the March 17th, 2022 order of this court, finding that there had been a breach at that point in time by the primary. And then as to the excess carriers, that the interest would only accrue from that moment in time. The reason for this is the exhaustion clause, which is contained in the excess policy. It's very clear.
Counsel, you rely a great deal on J.P. Morgan versus Vigilant, correct?
We rely extensively on that, correct.
The language is slightly different in that exhaustion clause. Does that matter?
No, Your Honor, it's exactly the same. In fact, the record shows that before the Supreme Court, we put in the affidavit of a Liberty employee with familiarity with both cases, and she affirmed that the language was exactly the same. So it is exactly the same language in both. And moreover, when we look at the bankruptcy case of Rowena, Rowena expressly uses that phrase, being held liable to pay, when it relies upon J.P. Morgan in reaching its decision. So the language is the same. Moreover, we would submit that in the sort of trio.
But in the Vigilant case, though, is it again being held liable to pay? That phrase is not in that case, is it? Perhaps I'm mistaken. I don't mean to stop you in your tracks.
Yeah, it is. We would submit, too, that, you know, we cite a trio of cases, and essentially in those cases, the language is functionally, if not literally, the same. And the issue that arises is, you know, the 5001 interest, contrary to what our adversary stated, it's not a penalty for an extra contractual liability. It's a question of at what point was the insured deprived of the right to use the funds, to have the funds in hand, and that's the same as it is with any accident, with any breach of contract, with any case looking at 5001. And here, with the exhaustion provision, what the exhaustion provision makes clear is that as to excess policy coverage, that coverage kicks in at the point in time at which the underlying carrier has paid, or that there has been a court determination holding the underlying carrier liable.
Thank you.
I see my time is out, but I think I was the 4 minutes and my colleague was going to be the 2 minutes.
Oh, I thought you were the 1 minute.
I
Okay, go ahead.
apologize if I went forward, but I would just address a little bit more if it pleases the court. So what we see is we are functionally equivalent to the three cases, and the bottom line holding of those cases is that there is only exposure, there's only a temporal obligation, a timing, an occurrence, a trigger for the excess policies, where in fact there's been one of two occurrences happening. One is that the primary actually pays, or second, that the primary is held liable to pay, and held, of course, being a connotation of somebody else holding the primary liable to pay. And the significance of that is that without that benefit to the insured, without the excess carrier saying, okay, you know what, we understand the primary may never pay you. You may have to get a judgment. You may have to enforce that judgment. You may have to, collect on that judgment. So if we only use the word pay, you won't have the benefit of our policy because we can sit back and not pay you at all. Instead, what the excess policy does is it benefits the insurer to the extent of saying if the court holds them liable, so they may not be able to pay because they go insolvent, but if the court has held them liable, we will step in and we will step up and we'll pay even though there hasn't been actual payment below. And that's in tune. The interpreting the language in the MF Global policy is very much in tune with all the other policy, the language that you see addressed in those other courts. If you look at, particularly with Rowena is the bankruptcy of the GM estate and the bankruptcy court. I mean, and whenever we see bankruptcy courts, frankly, we see them always trying to pull in as much money as we can and not giving a free ride to anybody and not giving a windfall to insurers, as has been characterized in this case. And the court there looked at 4 or 5 or 6 different types of exhaustion provisions and saw that some of them were strictly pay, some of them were pay or held liable, some of them, they had different language, each of them. But the court came back to the same position on each of them and said, yeah, the purpose of this provision, the reason for this language in the contract is so that it's very clear that the insured will get the benefit of the excess coverage when there's been payment in this case, and or if they've been held liable. But it didn't go so far as to rewrite that language. None of these cases have gone so far as to rewrite the language and say, we're going to retroactively decide that exhaustion occurred 8 years ago. In fact, Judge Ramos's decision, frankly, in Vigilant 1, we'll call it, JP Morgan 1, did sort of make that determination. Judge Ramos made the arguments that MF Global makes now, which is that it was a windfall, that it was unfair, that it was inappropriate for the excess coverage to not do anything, to not pay. And in fact, this court overturned that decision. Thank you, Your Honors.
May it please the court, Gabriela Rickheimer, and I am the 1-minute arguer, hopefully. Just briefly, I represent Axis Reinsurance, and there's been a contention that Axis waived the argument with respect to the accrual of prejudgment interest. So I just want to clarify a few things in the record. One, Axis signed on to the Liberty bond, so we join, or my client joins in the arguments of Liberty and is in the same position. MF Global on page 13 of its reply brief acknowledged that Axis raised the issue of exhaustion in 2017, but it doesn't stop there. In 2017, MF Global, in fact, responded to the arguments that were put forward by Axis and the other insurers, including Liberty, and acknowledged that there was an exhaustion provision in the policy, so there's no surprise here. MF Global had the opportunity to address the issue below. It was raised timely below. And so I'll just draw, given the briefness of my time, for your honors, I'll draw your attention to the Fox Group case that we cited in our brief. This court specifically noted the plaintiff had addressed the issue on the merits without claiming surprise or prejudice. Hence, defendants did not waive the defense. We say that's foursquare with the situation here. MF Global had the opportunity and did reply to it and never argued waiver really before today. So if your honors don't have any questions, I'll sit down.
Thank you.
Thank you.
The settlement agreements that are all in the record very clearly delineate between payment of loss and payment of above loss. They very clearly state that there was an exposure of these insurers to above limit claims based upon breach of contract. The above limit exposure was for prejudgment interest on their own breach of contract and on attorney's fees. These settlement agreements very clearly separate those, and they very clearly state that not only was it a release of the claim, but they were releasing and buying peace on the above limit exposure. Very separate. And when you look at what can be applied to deduct the loss that's collectible under 6.7, it's very simple to separate the amount that was paid to reduce the direct financial loss incurred as a result of Dooley's loss, which is the limit payment of loss, versus the above limit payments, which were not paid for that loss caused by Dooley. They were paid to satisfy those settling insurers' own malicious conduct, own breach of contract, and their own
Counsel,
liability.
can you turn to the cross appeal by Hampshire, by New Hampshire?
Yes. There's no basis in the statute whatsoever to toll prejudgment interest here under 5001. The First Department has very clearly stated that there's no equitable exception, there's no tolling. There's certainly no case that tolls it for the bankruptcy stay. The cases that they do cite don't apply. The one exception is if you can contract out of paying for prejudgment interest on a contract claim. Right. They refer to New York cases as saying that there may be an equitable-based exception to prejudgment interest accruing on a breach of contract claim under 5001. Not a single case ever carves out and gives an exception for a windfall or any other equitable-based exception for a prejudgment interest claim. And here, there's no windfall to MF Global, certainly. The insurers had the use of MF Global's money not only during that whole period of the stay, but during the whole period of 14 years of the pendency of this case. To say that MF Global engaged in any gamesmanship, there's just simply no gamesmanship. They waited a year before they sought relief from the bankruptcy court, and the MF Global trustee, who was the court-appointed trustee, a fiduciary to protect the assets of the estate, said that we'll go forward with the appeal and go forward, and that's what the bankruptcy court agreed to. It's in 506 of the record. The last thing I would like to address is the liberty point. You know, Your Honor, you hit it right on the head. There's not a single case that deals with interpreting the exhaustion provision at issue here, and it's very specific language. It's exhaustion when the underlying limits, let me back up just 1 second. Liability attaches when the underlying limit of liability is exhausted by reason of the insurers of the underlying policies being held liable to pay. You're correct. That language was never addressed in the vigilant case. The only language that was addressed in the vigilant case was when the underlying insurers actually paid. The Rowena case, all of those other cases, the policies there specifically, expressly, and very clearly tied liability that was triggered to the date of a judicial determination of that liability of the underlying insurers. That is not the case with respect to being held liable to pay. And in fact, Liberty even acknowledges that the Supreme Court, to come to the conclusion that it did, to trigger not from the date as of when the underlying insurers are being held liable to pay, which is what this means, but she had to change the policy, change the word being to were or are, rewrite the policy in order to come to that conclusion and tie the triggering of that liability to the judicial determination. That is incorrect. It's very clear in our briefs that the being held liable to pay the liability is triggered as of the date that the underlying insurers are being held liable to pay, and in this case, it's July of 2008.
I know this may sound like a silly question, but 5001 requires interest to be paid on a sum awarded. There was no sum awarded here, historically, when they settled with you, these settling insurers.
That's an interesting question.
And just another point. I just lost my train of thought just on that point. But So you would agree with that, correct?
I would not, actually. The way that I would answer that, it's no different. It doesn't matter that the settling insurers were not ultimately subject to the court's holding of the underlying insurer being held liable, because they stand in no different position than the primary insurer. That ruling applies to them. And in fact, these settling insurers actually acknowledged that their liability went back to the beginning because they paid prejudgment interest. They
Right, so-
acknowledged
and
that.
I'm sorry, I don't mean to cut you off, but at the end of the day, if I'm not mistaken on this record, from that $141 million loss, you ultimately got $161 million?
Not in principal loss, absolutely not. What was collected was $97 million in principal loss. The remaining was left to the excess insurers here. That's $43 million in principal that they're contractually obligated to pay. And they should not get the benefit of any above-limit payment by these settling insurers to reduce their contractual obligation.
Thank you.
Thank you, Your Honors.
Just a few brief points, if I may, in response to your exchange. There's no question but that MF Global received, under Supreme Court's order, the full amount of the claim loss, that amount not in dispute, $141 million, plus $22 million in prejudgment interest. With respect to your question about sum awarded, at pages 34 to 35 of our brief, the case that's at issue there is North River, explains why, as Your Honor suggests, you cannot get PJI on a settlement because there is no sum awarded. Turning...
Counsel is answering the question that the court asked.
With respect to the bankruptcy stay, Ms. Doherty is correct that there is no New York case on point. That is because this is a very unusual circumstance in which there was a stay issued by a bankruptcy court, and when the insurers attempted to proceed with the litigation in state court, MF Global refused to lift the stay. The only two cases we found on point with similar questions about what happens when you have some other jurisdiction issue a stay to prejudgment interest are the ones that we cited. And in the Michigan case that we cite, the statute is effectively identical to New York's. It uses the word shall. We do understand how robustly this court has enforced the prejudgment interest requirement, and we're just asking you to clarify that it need not be the case that an exception has to be codified in statute, but that there is some room in specific circumstances, like punitives, for example, and to ask Supreme Court to consider whether this very specific circumstance is one of them. Thank you, Your Honor.
Thank you. Thank you all.